Welcome, gentlemen of the press and the ladies. This is a world press conference on the defiance by the Central Bank of Nigeria and the federal government of Nigeria of a Supreme Court judgment in favor of Interstella Communications Limited and O.B. Thompson, delivered in appeal number SC 500/2014, December 15, 2017. Almost 2 years after the delivery of the judgment by the Supreme Court of Nigeria on December 15, 2017, in appeal number SC 500/2014 in favor of Interstella Communications Limited and O.B. Thompson, the judgment creditors, against the Central Bank of Nigeria and its principal, the federal government of Nigeria. Judgment debtors here. The said judgment debtors have persisted in their defiance of the Supreme Court, which ordered the payment of a long-standing judgment debt to Messrs. Interstella Communications and O.B. Thompson in affirmation of an earlier judgment of both the Federal High Court and the Court of Appeal in suit number FHC UMM 85 of 2011 and appeal number CA 0W 199 2012 respectively, as encapsulated in the advertorial place on pages 10 and 11 of this day newspaper of October 2, 2019. The judgment creditors have repeatedly appealed in writing to the Central Bank of Nigeria and the federal government of Nigeria to pay the judgment debt, now left with no choice than to proceed with all enforcement options provided by the law. However, before activating the enforcement steps, the judgment creditors have been very agitated by some questions thrown up by the inexplicable defiance of the Supreme Court of Nigeria, by the Central Bank of Nigeria, and the federal government of Nigeria, which they now want to share with the Nigerian public and the world through this press conference. The questions are rising. 1. Has the rule of law been suspended in Nigeria? At this time, when there are concerns in the international community over the status of the rule of law in Nigeria, this long-running defiance of the Supreme Court of Nigeria in the instant case is certainly counterproductive to the efforts being made to assure the world that democratic tenets and procedures still govern and control the way power is exercised in Nigeria. In the instant case, the impression being conveyed, unfortunately, is that the rule of law has been suspended in Nigeria. Otherwise, how else can anyone explain the brazen defiance of the Supreme Court by a democratic government? The second question: is there a supervening extra-constitutional government different from the constitutionally elected Buhari administration? The judgment creditors have it on good authority that after receiving and studying the aforementioned Supreme Court judgment, the Honorable Attorney General of the Federation of Nigeria, who as the Chief Law Officer of the Federation is the only statutory and constitutionally empowered entity to advise and guide the federal government on legal matters, had written more than once to the Presidency and strongly advised that the federal government and central bank should comply with the said judgment of the Supreme Court. Given the above facts, one wonders and should in all fairness ask, and I quote, from what source then did any other entity derive the power to act so cavalierly and with such brazen impunity as to ignore the specific final orders of the Supreme Court of Nigeria, as well as the statutory and constitutionally mandated advice of the nation's chief law officer without consequences? The third question: is the Buhari administration being sabotaged with a view to destroying Nigeria's standing before the Committee of Nations and present Nigeria as an entity where the rule of law has collapsed and individuals have gone rogue? With so many challenges confronting the administration, particularly in the area of non-adherence to rule of law and national security, The judgment creditors find it inconceivable that a straightforward matter as a breach of commercial contract agreement that has gone through the full gamut of legal adjudication in Nigeria, all the way to the apex court of Nigeria, and in which a clearly quantified monetary obligation has been established, is allowed to degenerate to this kind of controversy that could aggravate existing concerns in the international community over the integrity of our national institutions and operation of the rule of law in Nigeria. By the aforesaid Supreme Court judgment, the debt owed the judgment creditors stands at $285,124,422.30 as at October of 2019. $285 million with penalties still running every day. Derogating the judiciary to the extent that orders of the nation's Supreme Court are disrespected by the federal government sends a dangerous message to the outside world to the effect that nothing about or from Nigeria, tangible or intangible, ephemeral or eternal, including our governance, ethics, and morality, is at par with those of the rest of the world in committee. The frown and oddity so invited and attracted could push Nigeria right back to the pariah status she was once relegated to before May 30th of 1999. Those whose actions, as in the instant case, insensitively stir up such miasma once more, compel one to ponder over whether there is a deliberate sabotage plot against the administration, or could it be merely that indeed some individuals in the core of the administration have gone rogue? The fourth question we would like to raise is it a case of impunity? The judgment creditors have incontrovertible evidence of the fact that one of the correspondences last year between the Honorable Attorney General of the Federation and the Presidency, the Attorney General specifically stated that the judgment debt sum affirmed by the Supreme Court should be paid from available funds in some accounts in the Central Bank of Nigeria. In display of astonishing impunity, some entities at the Presidency overruled the Chief Law Officer of the nation and insisted that this particular judgment debt should wait until it is provided for in the budget. This stance was taken at a time when the federal government and the CBN were busy dissipating and disbursing hundreds of millions of US dollars from the excess crude account, the Paris Club funds, LNG accounts, etc., on paying other alleged judgment creditors, while the Supreme Court judgment in favor of Interstella Communications Limited and Obi Thompson are tossed aside, despite the Attorney General's advice and warnings on the damage such a conduct could do to Nigeria's national interests abroad. Shockingly, the same issue of paying the debt came up again recently. In September of this year, 2019, the same entities at the Presidency directed that the matter be once more redirected to the Federal Ministry of Finance for a review of the Attorney General's advice. Acting with absolute impunity is a fair label for such conduct. Inhumane and insensitive will also not be unfair when one takes into consideration that on the 9th of May 2014, long before the Supreme Court judgment that is being tossed around, the Court of Appeal sitting in Owerri, constituted by Owani Musa Abaji, JCA, presiding, Philomena Ekpe, JCA, and Peter Ige, JCA, in unanimously dismissing the FGN and CBN appeals, observed thus. This is what the Court of Appeal said about this matter in 2014. I quote, "All I perceive in this appeal is that the appellants want to use a lot of technical cloak and avenues to shield themselves from their financial and legal obligations to the first and second respondents. The government, which ought to be the armor bearer of the law, must not be supported to achieve its biased and capricious objective. Obviously, the first and second respondents have pathetically suffered colossal losses due to the frustration of the appellants to defray the judgment debts they have conceded and are responsible for. Obviously, using unavailability of funds earmarked in the budget for paying this particular debt is currently one technical cloak and avenue some individuals employ and hide under to achieve their biased and capricious objective of aiding the judgment debtor to dodge their financial and legal obligations at extreme detriment of Interstella Communications Limited and O.B. Thompson. It is also pertinent to add that Her Lordship Bataklar Ogumbi JSC, as she then was, in the lead judgment dismissing, this is now at the Supreme Court in 2017, in dismissing the frivolous appeal brought by the CBN in collusion with the FGN as cross-appellants, expressed surprise as why the CBN, being only a garnishi, went as far as it did to litigate the matter up to the Supreme Court in resistance of paying the debt, and thereafter struck out the federal government's cross-appeal as worthless and unworthy of the time of the Supreme Court. The Supreme Court looked at all of what had happened in the matter, folded the file, and threw it back at them to say, there's nothing for us to adjudicate in this matter. You breached a contract, you accepted you breached the contract, you've sat down with the person who is injured, you have all agreed on what you need to do, figures were put to it, and then suddenly you begin to run from one court to another. What do you want us to do for you? Since you are not denying the debt, the amount is not in controversy, concessions have been made to you. So the Supreme Court said there's nothing to look at, affirming the judgment of the Court of Appeal 2017. And we're in 2019, and the judgment is being trampled upon, urinated upon, by people who appear to be, in some higher, operational capacity than the government of the day. In a situation where the Attorney General had written, the Chief Law Officer of the Federation had written to advise that the debt be paid. Who else is now the one that is higher than the federal? Is there another government within the government? Is there some force higher than the government that was elected that could overrule the Supreme Court, overrule the Attorney General of the Federation? We need to know. If the debts are still not paid, 5 years after the Court of Appeal said the kind of thing he said, and the cream of and luminaries of our judiciary, some of whom have now deservedly joined their peers at the Supreme Court, could this be a case of discrimination? People are not as daft as the government think they are. People are looking at the map of Nigeria. Anything that happens, people are looking at who is from where, doing what. And what could be going on in their mind, you are not in a position to control. If you are acting in a manner that consistently creates an impression, people are going to take that impression as the truth of the situation. And so we're saying that at a time as this, when unfortunately Nigeria is tense with loud, acrimonious allegations on a scale that could rock the very foundations of the country against the administration, of indulging in acts of discrimination against individuals and people from certain sections of the country based on ethnicity and religion. Does the attitude of the federal government and the Central Bank of Nigeria towards the judgment creditor not raise legitimate suspicion in all fair-minded Nigerians as to whether the judgment creditors are not victims of such allegations, due cognizance being taken of the religion, the region, and ethnicity of the judgment creditors? What other reason exists than a deliberate negation of the judgment creditors' inalienable right to enjoy the remedies availed them by the courts of the land based on the principle of equal justice, equity, and fairness, which all Nigerians ought to enjoy? Maybe the answer should be left to blow in the winds. You know how the song goes. Even as it obviously appears consistent with a long-standing policy to financially strangulate, emasculate, disenfranchise, and disable some Nigerians. We are looking at the map of Nigeria in this discussion. Is it because these people come from this part that this kind of a thing should be done? Whatever is the truth, Let it now be noted that the judgment creditors are exhausted in their struggle to spare Nigeria the scale of embarrassment that could be worse for the country than the P&ID scandal. They are deliberately being forced to take inevitable measures offshore to compel the federal government and the Central Bank of Nigeria to obey orders of their own sovereign Supreme Court. Notice of consequences that have arisen. Let it also be known that the unlawful seizure of the judgment sums, which is the operating capital and only means of livelihood of the judgment creditors by the federal government of Nigeria and its central bank, has resulted in corporate death, as well as protracted emotional torture and trauma that are proximate cause of irreparable health damages suffered by O.B. Thompson, and which he continues to suffer. And there must be remedies in thought for these deliberate wicked acts of inhumanity by public bodies that have abused their power to wreak havoc and cause extreme harm to the politically powerless. It should be judiciously noted that the quantum of such inescapable damages awarded for the consequences of the aforelisted unconscionable behaviors of the federal government and the Central Bank of Nigeria increases in the duration of the said illicit conduct. It is also tried that the interest already awarded by the court for each day the debt is unpaid shall continue to run, as indeed the federal government and central bank have been forewarned by the Honorable Attorney General. This is one of the most important reasons for calling this conference.
Just a recap of,
okay.
Because what we've just been emphasizing is judgment debt and
yes.
and some of us really want to know what are the issues, why the people to court, what happens to the process and all that. That's one.
Yes.
Then the second question, you did mention that there's an interest on that.
Who is really helpless in this situation? Is it the judiciary that is helpless? Is it the executive that is helpless? Or is it Interstella that is helpless? Thank you. I want you to tell us in Naira cash,
yes.
Don't spend dollars here.
Yes. How
much really is the quantum of the money we are talking about?
Yes. Interstellar Communications, the owners actually lived in the US, and they knew this. They knew what the needs will be. People are so eager to get to being able to make telephone calls, but you can see now that data is even the more serious question. And he went ahead of the pack at the time to apply for the license to build data network that could be that will now back up whatever the other people were doing. And he was awarded that license. He paid for it. The company paid and began to build the network, the infrastructure. And it came to where it was already working, and somewhere from the blues, Nitel yanked off the connection with the gateway. That is the whole basis of the license is that they are able to connect with existing facility, just like the GSM started with existing facility before making their own arrangements. And from that point on, all of the investment went into disarray. What if you can no longer carry out the business of the license? It's just like yanking off MTN or Globacom from the facility that connects them. Then the company came to ask what the problem is, and Nitel could not furnish any. There was no breach alleged. There was nothing Nitel could point at other than order from above. Order from above. That was the only explanation. Of course, Interstella went to court. The matter was getting out of hand. It came to where the then Minister for Communication, Chief Cornelius Adebayo, had to step in to set up an interministerial committee to look at because it was a very serious problem. It was going to become a setback to the GSM technology that was just coming up. And that interministerial committee, came to where they asked Nitel this same question you're asking now. So Nitel, what is it that went wrong? Why do you have to disconnect a company you licensed that paid? Nitel said they had order from above. The minister said, look, as it is, quantify what it has become. They had to set up an alternative dispute resolution, ADR, and they arrived at a figure. That figure, they began to negotiate, and they agreed to pay if some concessions could be made. Interstella Communications made a 50%, that is considered half of the money, so that they could be paid at that point. It came to where the president, the president of the time, Umar Yar'Adua, just said, look, all of you pay off this money so that nobody hears this story, because it was such a nasty story to tell. At the time, Nigeria was going about looking for who and who will come to invest in telecoms. In the midst of all of that, the monies that ought to have been paid, some forces in government, because Yar'Adua took ill, they dumped it aside, paid just a token, and took the rest. Eventually, it became something that had to now go back to court, and it went in form of garnishing proceedings, because there's now a figure that is settled, entered as judgment, as a consent judgment. It was that consent judgment that became the basis of the garnishing proceedings. Of course, the court agreed with the company, gave the order that became absolute. They will not pay. Then had to go to Court of Appeal. I mean, what at law, if the matter is one in which you had quarreled, then you came back to round table and agreed on a figure, and both of you come back to court to register it as consent judgment, the court will not listen to you thereafter. But here was Central Bank, because they were the ones, they were the custodians of the funds of the federal government, was guarantor from the point of all that adjudication, and then that was how the matter went to Court of Appeal, which was why the Court of Appeal was so put off by what they saw. That you are not saying that there's no obligation. You have yourself written down what you thought was the fair figure, the fair quantum of money to be paid for your wrongdoing. You can see that was how they still went to Supreme Court. In all this period, if you were to know what third parties who were being owed offshore, if you were to know the number of employments that got destroyed, if you were to know the number of businesses that got destroyed, that's why the Supreme Court refused to even look at it. The Supreme Court said, look, that this is not worth our time. Is there in the you will see the references. 2 years after, no step has been taken to comply with that order, despite repeated demands, despite letters from Attorney General, at least we are aware of two, in which Attorney General was saying to the federal government, look, there's no remedy we will find if this aggrieved party goes to seize whatever they find to seize, whatever they begin to do to recover this money in any part of the world. It's coming to that. But we want to start at home, because this company had in mind the interests of this country at the time it took the risk of coming to plunge money borrowed from outside in their own economy. And look at what has happened to it. Which international investor in his right mind will come to put money in that kind of economy? And we're in a democracy. Is that the answer? Then we come to Daily Trust. Say, who is helpless? From what we've heard, from what we've read, it certainly is not central bank. They have money in the kitty, except they come to tell us that there's a force that is preventing them from taking the money to pay. It has to come from them to come to tell us, because contempt proceedings have been initiated against the central bank governor. It was also published in the dailies not too long ago. So if they're in a helpless situation, they will have to be the ones to say so. Our only suspicion is that there's something that they are not telling us. Is it the government that will be helpless in a situation where the Attorney General has written, the one who is constitutionally mandated to advise the government on such matters? He has written not once, at least twice, it could be more, but the ones we got to know about, it certainly cannot be the federal government that is helpless, except there's a supervening extra constitutional government, a government that is higher than the one we elected. That's a point of suspicion. And we're saying that if the Attorney General has advised and it's not being done, then we must probe more deeply to see whether it is the government we elected that is still in charge of the management of this country. Is it Interstella that is certainly it is Interstella that is helpless at this point in terms of what can they do to go to take money from the treasury. For a company that have been battered this long in the sums of monies we are talking about, $285 million as at today. At the time the judgment came in 2017, December 15, they computed everything and it came to $260 million. It is the interest that the Supreme Court ordered, affirmed, from that time that has brought it to the 285 it is today. And that interest is still running. If we were to talk in terms of naira, by the time you convert at the base rate of 350, that is just the minimal. It could be more. But 350 naira to $1 brings us to where we could be discussing anything, between 95 and 100 billion naira. And for this kind of damage to be inflicted on individuals, it's just a group of individuals that try to help their country that was in the dark. This was in telecoms. Who would then go to help this country with electricity? Because it takes people who have access. People like us can tell General Electric, come with us. General Electric will not lift a finger, no matter what you tell them, if they are not assured that when things go wrong, because you must consider if things go wrong. It's investors' money you're talking about. It could be $5 billion, it could be $10 billion. Who is going to plunge investors' money in this kind of unsettled atmosphere? And if the rule of law has collapsed in Nigeria, then the earlier we are told, the earlier the international community is told, and the earlier the international community gets to know, we are saying that the people causing this situation, the people steering the situation do not know the gravity of what they are doing. They are looking at money. They are looking at other considerations. But they are hitting Nigeria where it hurts most. What Nigeria needs most at this time is what they are damaging by their recklessness. Do you have an answer now, sir? It's that this particular company has been too mindful of what will happen to the country that is already suffering. This company can get this money overseas this company can get this money by execution. There are rules for what to do with court judgments, and none of those things will be off the table going forward. That's what we want to tell everybody. Thank you very much.
On behalf of the chairman, we wish to express our thanks for your patience, for honoring our invitation. Just like the last person said, asked, what will be the next line of action? I think that line of next action has already started by intimating the media, who has the responsibility of, who has the duty to inform the nation on the state of affairs. And by informing the nation, you're already forming their opinions, because we can't live in a country where things are going haywire and everybody don't seem to know. I think that's the duty of the media, to carry the information across to the public for them to know, so that in case if action is taken tomorrow, the people who are supposed to start commenting would have already been acquainted with the background of whatever action is going to be taken. And we believe if the populace are now intimated, of course those at the end of affairs will now have everything. So please, we now appeal to you to now do what needs to be done for this thing to be settled internally before going outside the shores of Nigeria. Thank you.